If there is not a right to life, then what life is that? What rights exist, if not the elementary, fundamental, profound right to life?
After Governor Henry McMaster signed the fetal heartbeat bill banning nearly all abortions in the state, Planned Parenthood, South Atlantic, and the Greenville-Women's-Clinic filed a lawsuit alleging the bill violates the Constitution, claiming it doesn't give women enough time to get an abortion after learning they're pregnant.
Matt Koufax spoke with a lawyer from the Center for Reproductive Rights representing the upstate groups and with upstate lawmakers from the state GOP to get their response. He's live outside the Greenville Women's Clinic. So, Matt, what did you find out?
Well, Cody, Tori, there are a lot of moving parts still and a lot of questions that we still need to answer. But one thing that both sides of this issue agree on is that a tremendous legal battle could be looming. The lawsuit brought by the folks here at the Greenville Women's Clinic and Planned Parenthood would seek to stop this bill, which most state Republicans are calling a tremendous achievement in protecting life, from going into effect at all. Alexandra Thompson, an attorney for the Center for Reproductive Rights, says the new South Carolina heartbeat bill is, quote, blatantly unconstitutional, referencing the Roe v. Wade decision of 1973.
The Supreme Court has held for nearly 50 years that states cannot deny people the right to end a pregnancy prior to viability.
Viability of a fetus to live outside the mother is defined at 24 weeks, or 4 times the amount of time allotted to get an abortion in the bill. Thompson says reproductive rights are human rights and that this bill targets certain groups.
Black people, people of color, people in rural communities, low-income folks, people with disabilities. It just seeks to make it harder and harder for people to access their constitutional right to abortion in the state.
Circumstances have changed, technology has changed, and to say this is unconstitutional is wrong. And to say that it challenges viability is not the only test here.
State Senator Josh Kimbrell, one of the bill's sponsors, says he's not surprised at the lawsuit, just disappointed.
We're talking about literally a beating heart, which medical advances and science have proven that we can determine this, where in 1973 they couldn't.
He says exceptions Republicans added to the bill, which would allow for abortions beyond 6 weeks in cases of rape, incest, or danger to the mother's health, are reasonable, and that they feel confident about where they stand legally.
I frankly believe the way we tailored the bill, I think it will withstand constitutional muster once we get to the Supreme Court of the United States, and that's where this ultimately will end up.
Obviously, a big battle looming. This bill has been the subject of vicious debate in recent weeks. And Thompson tells me that it will be a hearing. They got a letter today saying that they're going to have a hearing at the federal courthouse in Columbia on this tomorrow. She says they are ready to go. Other states where similar bills like this have been passed have seen federal judges allow injunctions while the challenges are being heard, meaning the legislation has been effectively temporarily blocked. Kimbrell says that the legislation they have here is different from states like Georgia, where no exceptions were added. That's why he thinks they are on firm ground. Regardless, right now as it stands, there has been no bill like this permanently put into effect in any other state in the country so far. In Greenville, Matt Koufax, Fox Carolina, the 10 o'clock news.